Now that your case is being appealed, you'll need to argue it again to a new set of judges. You've probably briefed the issues before in a motion or post-trial brief, but writing an appellate brief is a different task. If you're the appellant, you have the burden to show that the court below made an error, or errors, requiring its decision to be reversed. For example, if your client lost at trial on a fraud claim, you might argue that the trial judge improperly admitted hearsay statements about your client's intent. If you're the appellee, also called the respondent, which we'll call it in this course, your job in the brief is to show either that the court below didn't make an error, or, if they did, the error was harmless because it didn't affect the outcome of the case. You might make both of these arguments in the alternative. In the fraud example, you could respond that the testimony fits into a hearsay exception, so it was properly admitted. You could also argue in the alternative that even if the testimony was hearsay, other evidence showed the fraudulent intent, so the error was harmless. The standard of review for an appellate brief varies based on the issues on appeal, and a court might apply different ones to different issues within the same appeal. Typically, the court will apply one of three standards: de novo, clear error, or abuse of discretion. Under the de novo standard, the appellate court reviews the issues anew, with zero deference to the lower court's analysis. This is the standard generally applied to legal questions. For example, the court interpreting the language of a contract. Appellate courts are a higher authority on questions of law, so it wouldn't make sense for them to defer to a lower court on these matters. Under the two other standards, the appellate court gives substantial deference to the lower court's decision. The appellate court will only reverse if the decision is plainly unsupported by the evidence. The analysis is basically the same under these two standards, but they apply in different situations. The clear error standard typically applies to findings of fact, which are about interpreting evidence, not analyzing legal issues. For example, while interpreting the contract language was a legal question, finding whether payments were made would be a finding of fact. Since the lower court was involved throughout the litigation, they had the better understanding of the evidence, so appellate courts try not to disturb their findings of fact. The abuse of discretion standard applies to certain questions that are known as discretionary decisions. These are decisions where the lower court's role is to exercise its own judgment based on fairness, a combination of legal and factual considerations, or whatever the judge deems appropriate under the circumstances. Things like discovery disputes, scheduling issues, and motions for sanctions are examples of discretionary decisions because the right answer depends on the specific circumstances of the case, which the lower court is most familiar with. Appellate briefing is governed by its own rules of procedure, like the Federal Rules of Appellate Procedure in federal court, known as FRAP. A lot of appellate courts also have local rules with detailed guidance for briefing appeals. Appellate courts usually have much stricter rules than lower courts do, and they enforce them more strictly too. If your filings are late or not properly done, chances are your papers will be rejected, and you could also lose the chance for oral argument. So you'll want to study these rules closely, even if you're familiar with appeals. Some of the strict appellate rules you'll see are for things like font size, margins, and footnote size. For example, under the FRAP, briefs must be no more than 30 pages, using either a 14-point proportionally spaced typeface or larger, or a monospaced face containing no more than 10.5 characters per inch. And the FRAP says that 25 copies of each brief need to be filed with the clerk, and 2 copies have to be served on all other parties. If you've already forgotten all that, it won't come as a surprise to you that many lawyers use an appellate printing company to make sure their briefs follow all the rules. An appellate printer can do everything from formatting and printing the brief to filing and serving it, so you can focus on the content.